Good morning. Oops, what did I do? There we go.
Morning.
Good morning.
How are you doing?
I'm good. How are you?
Good. You staying warm?
Uh, inside, yes.
My fireplace has been running nonstop.
I bet.
Ugh. Let the dog out this morning and he was out there for about 10 seconds, turned around and was just like, no, mom, no.
Go back and nap in front of the fire.
I know. I was like, well, you better hurry up and take care of business, bud. 'Cause- Oh. But hey, at least it's not ice storms.
Yes. It could always be worse.
Mm-hmm. Let's see here.
I will go ahead and call to order this hearing of January 23rd, 2025 in the matter of appeal of Z0375-24, a request for a multi-dwelling land division. My name is Joe Turner. I'm the county's hearings officer. I'll start with some brief announcements and a summary of the process that will follow, so everyone understands how you can participate in the hearing. I start by saying I'm not a county employee. I'm licensed as an attorney and trained as a planner. I serve under contract to the Board of Commissioners. I say that so you know you're getting an independent review of the application before me today. My role as the hearings officer is to conduct the hearings and make decisions about certain land use matters in Clackamas County. In making those decisions, I'm required to apply the county's existing laws. I'm not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Planning Commission and Board of Commissioners to do that. But state law requires that this application and appeal be judged based on the laws in effect when the application was filed. As a hearings officer, I'm to provide an unbiased decision maker. I believe I am unbiased with regard to the application before me today and appeal. I don't have any interest in the subject property or any of the surrounding properties, and I haven't had any, excuse me, had any pre-hearing contact with any of the parties regarding the substance of the application. But anyone has the right to challenge my impartiality, to argue that I'm biased in one way or another, and you can do that when it's your opportunity to testify. Procedure will follow. I'll start by asking staff to summarize their staff report and respond to the appeal. Then the applicant/appellant will have the opportunity to present your appeal, respond to the staff report, and present any testimony you want, other testimony. Then if anybody else wants to testify about this appeal and application in support, in opposition, or with questions or concerns, they may do so. Once everyone's had an initial opportunity to testify, I will give staff and the applicant alone the opportunity to respond to the testimony that was offered. If those responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing and announce what I'm going to do. Generally, I will issue a written decision within about 2 weeks after the close of the public record. I'll send my decision to the county. The county will send it to parties of record. So anybody who testifies orally or in writing before the close of the record will have the opportunity, will receive a copy of my decision when it's issued. If you decide you don't want to testify, but you want to receive a copy of my decision, you can contact county staff and they'll put you on the list to receive a copy as well. Anyone with an interest in this application may offer relevant oral or written testimony. But testimony should be relevant to the applicable approval criteria, which are set out in the staff report. Also, please don't repeat testimony offered by yourself or earlier witnesses. Repeating your testimony doesn't make your case any stronger. This is not a popularity contest. Whether everybody loves it or everybody hates it is not an issue I get to consider. The only issue before me is whether the application does or does not comply with the applicable approval criteria. It's also important that all parties make their best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals, or LUBA. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, you need to make sure it gets into the record before me. In order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the hearing, or the record rather. And in order to raise an issue on appeal, someone must have raised that issue before me with enough specificity that everyone can understand what the issue is. If you feel you need more time to prepare, you can ask me to hold the record open or continue the hearing. If I hold the record open, you'll have the opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. Whether or not the hearing is continued or the record is held open for any other purpose, state law requires that I hold the record open for an additional week for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that right if they choose, but if anybody else wants me to hold the record open for any other purpose or to continue the hearing, they must make that request before the close of the hearing today. Also, my decisions must comply with state law that requires that I issue a final written decision within 150 days after this application was filed. So there's some limit to how long I can continue the hearing or hold the record open. When you testify, please begin by stating your name and your full mailing address. Please spell your last name so I get it right, although, well, several people just have their first names listed. So please spell your last name and that concludes my introduction. Staff will give us a brief overview of how the Zoom process works, and then we'll proceed with the hearing.
Ready? Thank you, Joe. So let me read this the script here. This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by county staff moderator. Audience members' videos will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees on PC and iPad, you have a raise button on the Zoom bar, top or bottom depending on the device. When a moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all participants' cameras, not just the one who is speaking. Staff will call upon you when it's time for you to provide testimony. Be sure to provide your name, mailing address when you begin. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, email written testimony to arodriguez@clackamas.us or mail it to Clackamas County Planning and Zoning Division at 150 Beaver Creek Road, Oregon City, Oregon 97045. The staff contact email address is also available on the webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive the hearings officer's written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address by emailing it to staff contact for the application or by entering it in the Zoom chat function during the hearing. Ready? So let me pull up my PowerPoint. Okay, so I'm just gonna preface this with what's gonna be my PowerPoint presentation. It will be the subject property review, the proposal review, and the criteria that's not met. So first is the subject property review. It's on Township 4, Range 3E, in Section 18, tax lots 1700, 1701, 1702, and 1703. There's two addresses associated with the property, 18270 South Old Clark Road and 1828 South Old Clark Road. I just want to point out that the shop, the rental unit, is on 18720 South Old Clark Road, and then the stick built, which we'll be discussing later, is on stick built house is on 18280 South Old Clark Road. The zoning is timber, and the total lots equal 4.89 acres. I do want to point out that I do have the tax lots here highlighted. And this is from Plan Map, and it's not necessarily the current property configuration specifically for 1702. I provided my highlighted kind of site plan of what the current configuration of 1702 is. There was a recent property line adjustment that reconfigured tax lot 1702, which is highlighted in this maroon highlighter. So next we'll go on for the proposal overview. The applicant applied for a multi-dwelling land division based on the existence of two single-family dwellings on the subject property, an 1967 rental unit apartment with an accessory building on 18720 South Old Clark Road on tax lot 1702, and a 1973 stick-built dwelling at 18280 South Old Clark Road on tax lot 1701. 17 lots 1702, 1700, 1701, and 1703 form one lot of record. The applicant proposes to divide the subject property into two parcels. One approximately 2.05 acres containing the 1767 rental unit, and one of approximately 1.22 acres containing the 1973 stick-built dwelling. Tax lot 1702 was involved in a recent property line adjustment, as I mentioned earlier, under case Z0126-24 with the adjacent tax lot. Let's see here. 1704, which is a separate lot of record. The application is being denied because the 1767 apartment dwelling was replaced with a manufactured home in 1998. The manufactured home is located on tax lot 1704, which, as is discussed above, is a separate lot of record. When the 1998 manufactured home was placed on tax lot 1704, the 1967 apartment home was supposed to be removed or converted into an accessory structure. The initial decision from staff was denied, and the decision was appealed on December 22, 2024. So this is the site plan that was provided. As you can see, this is the new configuration of the lots, and you can see where the stick-built house is proposed to be the lot line on 1.22 acres, and then also configuration of the lot with the dwelling, the rental unit shop, which is proposed to be 2.05 acres. So the approval criteria are that is going to be discussed that was not met. There's one more section, but this is what that I'll discuss further in my PowerPoint, but this is the two ones that we'll be discussing in my next few slides. Is the ZDO section 406.05 D1 residential uses. And I kind of specifically highlighted some of the criteria that we'll be looking at in my staff report that I reviewed, and also in my PowerPoint. And I'll just read out the kind of first section. A lawfully established dwelling may be altered, restored, or replaced if the dwelling to be altered, restored, or replaced has formerly had the following features. Formerly had means the dwelling possessed all the listed features within 3 years prior to the date and application submitted for the replacement dwelling. So we're just going to go focusing on the first highlighted section. So under 406.05 D1, it states a lawfully established dwelling may be altered, restored, or replaced, and criteria. Staff interprets lawfully established dwelling as a dwelling needed to be currently lawful. So meaning that in addition to it being permitted, which it was, it needs to be currently lawful. Staff provided a copy of the 1998 manufactured home permit, the replacement dwelling agreement for of the 1967 dwelling, and a visual map created by staff that clearly shows a 1967 apartment unit was replaced in 1998 under MH 027398. In addition, the replacement dwelling permit and replacement dwelling agreement site plan use words such as building, shop rental, replacement dwelling to specifically identify the 1967 apartment rental unit as the dwelling being replaced in the new manufactured dwelling by the new manufactured dwelling. Therefore, as shown in the supporting documents, and I have the permit and the replacement dwelling agreement on my next slide, provided as part of the decision, the 1967 dwelling was replaced under the MH 027398 in 1998, and it is no longer currently lawful and thus does not meet the standard. So this criterion is not met. So I provided the manufactured home placement installation permit and the replacement dwelling agreement. This is in my staff report as well. And as you can see, I highlighted some of the kind of details that correlate between the manufactured home that was replaced. I'm sorry, that the new manufactured home that replaced the rental unit, and of course the rental agreement. It's the same address, 18310 South Oak Clark Road, and that is the same in the replacement dwelling agreement. And it uses, as I mentioned, words as this is a replacement of an existing house, which is the rental unit, and of course it has the same manufactured home permit of MH 273-98, and as you can see, it's the same manufactured home permit. So we can clearly see that the manufactured home, the rental unit was replaced with this manufactured home. There's a second page to that replacement dwelling agreement that has a site plan that I included here. So we can see that it shows the shop building, and it says specifically rental, in addition to calling out the address 18310 South Oak Clark Road, and with it being labeled as replacement dwelling. I also included, these are in my staff report as well. I also included my site plan that I created, kind of showing this a little bit more in detail of the sequence of events and kind of the current status of the 1973 house. Just kind of repeating that this was a 1967 original dwelling replaced under the 1998 permit MH027398, and then the location of where that is. And as you can see, it's correlates to where it's shown on the site plan. Excuse me. So the next part of it is, we talked about the first section. The section I'll be discussing next is the which I highlighted. I'll just read out that section. The dwelling to be altered, restored, or replaced meets one of the following conditions, unless the value of the dwelling was eliminated as a result of destruction or demolition, was assessed as a dwelling for purposes of ad valorem taxation since the latter of 5 years before the date of the application, or the date the dwelling was erected upon or fixed to the land and became subject to property tax assessment. If the value of the dwelling was eliminated as a result of destruction or demolition, was assessed as a dwelling for the purpose of ad valorem taxation prior to the destruction or demolition, and since the latter of 5 years before the date of destruction or demolition, or the date the dwelling was erected upon or fixed to the land and became subject to property tax assessment. Just my finding summary, which is included in my staff report, is that staff concluded the dwelling was not eliminated as a result of destruction or demolition, nor has it been assessed as a dwelling for the purposes of ad valorem taxation for 5 years before the date of the application. Staff determined in the above that the 1967 rental unit was replaced on the tax lot 1704 under permit MH027398. Staff included current appraisal information showing that the property with the 1967 dwelling is not being assessed and taxed for a residence. So with consideration, staff still finds this criterion is not met. This is included in my staff report as well, and just kind of showing the assessment appraisal information current, that there is a difference in property characteristics. Dwelling number 2 with the 1973 stick-built dwelling has under property characteristics the single-family residence building category. And of course, it has the year built and so forth. The dwelling number 1 on the rental unit does not have any type of information regarding year built or building class category under any type of residential indication. And finally, this section, ZDO section 406.09B4, at least one of the existing dwellings is located on each lot or parcel created under this provision. As demonstrated by the applicant submitted site plan, each of the 2 proposed parcels will contain 1 dwelling. However, as demonstrated in findings, the 1967 dwelling is not a lawfully established dwelling, as it was replaced replaced by the dwelling currently located on tax lot 1704. So with consideration, staff still finds this criterion is not met. So this is staff's initial decision denial, and this is staff's recommendation is to continue that denial of the Z0375-24. And that is the end of my presentation. I have my contact information, email on there, if you'd like to reach out to me.
Okay, thank you, Mr. Rodriguez. The county's determination that it wasn't assessed, the apartment wasn't assessed as a residence, is based on the property account summary, but then the applicant submitted some additional with their, I think yesterday, their submittal yesterday from the assessor department. It appears to show that it was assessed as a residence. Do you have any response? Did you review that and you have any response to that?
I have not necessarily reviewed that exhibits. I think It could also, go back to, assessment's going to tax a structure regardless if it's permitted, and I think
Mhm.
it will go back to that it was replaced. That's
Yeah,
the current.
that's a different issue.
Yeah,
But
exactly. But I
part of the
guess
assessment, I just wanted,
yeah.
okay. I'll let the applicant present their case on that, and I may have follow-up questions on that, but I just saw um, their exhibits, and that it
Mhm.
appears to show that it was assessed as a residence. Um, okay, thank you, Mr. Rodriguez.
Yep.
Mr. Kruger, I understand you're the applicant. You'll need to unmute yourself.
Good morning. Yes,
Good
that's
morning.
correct. I'm the applicant. My mailing address is 18280 South Old Clark Road, as Aldo stated in the application and in his presentation.
And can you just state your name for the record, just in case somebody has to listen to this?
David Kruger.
Thank you, sir.
And my wife, Elaine Kruger, is a co-applicant. And I would like to correct that information.
Mr. Kruger, is it Elaine or Ellen? On my screen, it shows as Ellen.
It is Elaine.
I figured, I just wanted to confirm. Elaine?
That's correct.
Thank you.
And also in those opening slides that Aldo presented, just for the record, he showed that the total parcel size was 4.89 acres. That is incorrect. And then in the information that he provided, he showed that it consists of 1.22 plus 2.05, which totals 3.27 acres. And that is the correct figure.
What's the 1.22 plus 2.05? What are those from? The different tax lots?
That's correct.
Okay.
And that's the proposed division. The 2.05 is the one that contains dwelling number 1, which is the shop building that was constructed in 1967 with a residence. And the 1.22 acres is the lot size
Right.
of the
Okay.
stick-built home, which was built in 1973.
Thank you, sir.
Okay, so I would like to move on then. If you're ready, I have
I am.
okay. The information that we'll look at is I'll be presenting it as a PowerPoint file on my screen, so it fills the entire screen. On what was emailed in is actually a PDF file, but it's exactly the same information.
Mhm. I assume you're looking for the share screen button.
I've already hit it.
Okay.
I don't know, has it come up yet?
No. There we go.
Okay.
Yep.
And-
Now we're seeing your, your PowerPoint. Yep.
Right, okay. I'm waiting for this to move over to the full screen. Is that going to be okay, or
That
is
works for me. Yeah, as long as
with
works
part
for
of
you.
it covered, it's your decision?
yeah, no, it's perfectly legible.
Okay. This just states what the proposal is, and it's to divide that 3.27 acres that we've already discussed.
I think can you go down the slide? It's just showing the attention hearings officer and subject to appeal of December 19th, et cetera. It's on
Okay.
slide 1.
Well, that's interesting because I've moved it to slide 2, and
Hmm.
I'm not sure why it's taking,
Yeah, it hasn't happened here yet.
uh,
This is the same, this is the PDF you submitted yesterday, is that correct?
this is actually the PowerPoint.
Right, but you submitted it, yes, the same thing yesterday as a PDF?
That's correct.
Okay, I have that, so I'm going to open it on my other screen, my other monitor, so I can see both these, just in case we're unable to get past this technical issue. Because it is part, your PowerPoint's part of the record.
Right,
And
right.
this way I can follow along easier.
If for some reason, um, if it would work better that you share it on your screen, that'd be another possibility. And I could just tell you when to advance it.
Ms. Renner, do you have Exhibit 27? Can you pull that up? I think it'd be easier if staff does it, so I'm not trying to do two things at once. Follow
Sure.
your. So if you'll stop sharing your screen, and Ms. Renner, can you pull up Exhibit 27 and share that on our screens?
I can. Give me just a second to
Wonderful.
make this work here.
And Mr. Kruger, you'll need to stop sharing yours. There we
Right.
go. Technology always makes everything so fun.
Right.
There we go.
Okay, so if you could move to the next screen then. Okay. I just identified that the proposal is to divide that 3.27 acres that we discussed, which contains 2 lawfully established primary dwellings. And the request then specifically is to have the restriction released that will again allow the apartment to be legal in the 18270 shop building, and for the multiple dwelling land division application to be approved. Okay, next slide. Background. I met with Eric Forsell on the 11th of September in the office at the Planning Commission, and Eric and I had a not so short discussion regarding what the next step is that we should go through as to how we would get this approved. And he also discussed it with his supervisor, and he came back and stated that the multiple dwelling land division application is the correct form and that a pre-application conference was not required. Okay. Okay, the multiple dwelling and land division application, the document that is dated the 1st of July, that's the actual form itself from the county, as worded, and that's important, was signed and submitted with a $1,065 application fee in good faith on September the 16th, 2024, and submitted to Eric. The Planning Commission, in their December 19th notice of decision, stated they quote unquote interpreted the wording of the application form differently than is specifically worded in the application. Next slide. The reason for filing the appeal is that statements in the decision letter of December the 19th contain inaccurate, incomplete, inconsistent, and vague information as the basis for denial. Okay, next slide. In the findings section, which is on page 8 of the notice of decision, it says the findings below identify the standards and criteria that are relevant to this decision, comma, state the facts relied upon, comma. That's an incorrect statement because there is information in the document that is clearly incorrect. Next slide, please. This is the question copied directly out of the application, and the key words here are lawfully established and currently exist on the subject property, and it was answered to, as you can see here. Next slide. Staff interprets lawfully established as currently lawfully established. Interpreting what the multiple dwelling land division application specifically states versus how it's interpreted is two different things. Next slide, please. This may be a little bit small, but hopefully you can read it.
Oh, it's very legible.
Okay, good. Thank you for confirming that. Okay, 406.05 D1 makes a statement about how the building may be altered, restored, and replaced. The key facts are that dwelling number 1 and dwelling number 2 were both lawfully established in 1967 and 73, respectively.
Mm-hmm.
Both dwelling number 1 and dwelling number 2 currently exist on the subject property and existed on the property prior to November 4th, 1993. So the information here just confirms that, and these are the verbiage in the boxes is copied directly out of the staff report, confirming that both dwellings were lawfully established, that both dwellings currently exist. And now, because of this replacement dwelling agreement, it says it is no longer lawful today. And it's again restated. Well, the bottom one is an incorrect statement. It says no longer a lawfully established dwelling. We'll cover that in more detail later. Okay, next slide, please. This says the 1967 dwelling was not decommissioned as required. That's an incorrect statement. The prior residence has been decommissioned as required and is used for non-residential purposes. The following changes were made by the property owner without guidance from and follow-up by Clackamas County Planning and Zoning. The kitchen, the refrigerator was removed. The range is not wired for operation. The washer and dryer have been removed. The room containing the toilet and the sink, the shower was decommissioned subsequent to 1998 by moving the hot water heater into the 1967 shower stall, and we'll look at photos of that. Next slide, please. This says the reason that the 1967 dwelling has the current features is because of the owner failing to convert the apartment into non-residential use as required. That's inaccurate. Next slide, please. Okay, I won't read all of this,
Yeah.
but each one of these statements is an incorrect statement because the residence has been decommissioned and is being used for non-residential purposes. Next slide, please. This is a photo of the interior of the building. This slide was included in the initial application, and these 3 additional photos are of the same room, confirming that it's used for non-residential purposes and is used primarily for storage. Next slide, please. The slide or the photo in the upper left-hand corner shows the toilet, the sink, and it shows a door going into the shower area. The photo in the lower right-hand corner confirms that the hot water heater is located in what used to be the shower stall. Next photo, please. This room in the building, this top photo is the photo that was submitted with the initial application. And the 2 photos down below provide more detail showing and again confirming that it's used for storage. It's clearly not used as a residence. Next slide, please. Similarly, the photo up at the top shows the photo that was submitted with the initial application on the 16th of September, and the 2 lower photos again show the amount of parts and components that are stored in this room. It essentially is a storeroom. Next slide, please. This now deals with the taxation of the prior apartment. And the way it's worded, it's an inaccurate statement in that this states that the apartment dwelling is no longer being assessed. I'd like to point out that there's been 5 separate meetings with assessor personnel that have confirmed that it is indeed still being assessed as a 1,218 square foot apartment dwelling. This paragraph immediately below that identifies the dates of those meetings and the persons with whom I met. And the September 9th meeting was a very important one because had I not learned the information that I did, we would not have applied for the multiple dwelling land division application. And then subsequently, to make my information more complete, I went back in there 4 additional times. And out of the 5 different meetings, I independently spoke with 4 different people, all of whom stated the same information. The information that I submitted back on the 16th of September, the very lower item on this slide, confirms that that 1,218 square foot apartment was in fact included in the information that I submitted in the initial application. Next slide, please.
Before we move on, the bottom of the slide, there's that box, 1986 miscellaneous features. What is that from? Is that from?
It'll show us on the next slide, actually.
Okay, great.
We want to move on to, okay. This answers your question.
Great.
The very small slide that you can't read is a agricultural valuation record.
From the assessor's office, I assume?
That's from the assessor's office. That's correct. And this is, what is shown here is the first page of 2 pages that are in that one record. And both the first page and the second page are included in the last pages of this document for, well, we'll get to that in a minute. So this one is actually from the 2024 tax record, and it is underlined, miscellaneous features equals 1,218 square foot apartment in a 6 GP building.
You know what that is, just out of curiosity?
Uh,
No, it's fine. Just curious. I don't think it makes any difference.
the P stands for pole is what I've learned from the assessor's office. So it's
Whole building?
pole, P-O-L-E, I believe.
Yeah, that's right. Okay.
Yeah,
So
okay,
E building is pole building.
right.
Thank you.
Yeah, yeah. Next slide, please. This is a similar record, but from the year 2000. So keep in mind, the replacement dwelling agreement was signed in 1998. In 2000, that information was still there on the assessor's document, and we're being assessed for it. And the earlier slide that we just looked at is from 2024, and it's been in there every one of the years in between. Next slide, please. This is actually a duplicate slide by error, but it's actually good just for a summary, identifying that the information that we've already talked about was actually provided by the assessor's office by 4 different people in 5 different meetings.
I understand.
Next slide, please. Okay, this is a summary of the information off of those years of assessment forms. And this shows, and this addresses that 5-year ad valorem tax requirement, 2024, 23, 22, 21, 20, that's 5 years. Then I just skipped a number of years, and then the next one shown is 2005, and the last one, the year 2000. It's important to point out that these documents that the assessor's office provided me are agricultural valuation record sheets. Now, similarly, there's also one for residential that are of the same format. The information that was provided in the staff report are valuation records. They're a different document. And Aldo actually showed those in his earlier slides. They're a different format, and it does not give the breakdown identifying what items are being assessed, other than primarily land and buildings. Okay, next slide, please. In the replacement dwelling agreement that was signed on the 13th of July, 98, I signed that document in good faith, and through errors and omissions, the statement below in all caps was not followed by Clackamas County Planning. It says, please be advised that removal or conversion will be verified in the field by staff. Failure to comply will result in enforcement action by this department, which can result in the imposition of civil penalties. Well, interestingly enough, the Planning Commission also signed that same document, and as of today, the county's never come out to make that inspection. I signed the document in good faith. The question is, did the Planning Commission sign it in good faith? Next slide, please.
But whether or not they verified it, what difference does that make? You said you did, and you've got evidence that you did remove it or convert it. So the fact that they didn't confirm that doesn't really change anything, does it?
Well, it actually is important, and we'll cover that a little bit later.
Okay.
But thanks for the question. It's a good question. This slide deals with the errors and omissions that I referenced.
Mhm.
In my application, I stated that there have been recent residences approved on adjoining properties, and all of this information was included in material that was provided on the 14th of October. And down at the bottom, it gives 3 tax lot numbers, and prior,
I understand that those were approved, but how is it relevant to this application? Because those are different standards and different issues.
next slide, please. This, I understand your question, sir.
Mhm.
These were all approved to add a new single-family dwelling.
Mhm.
And it's interesting because prior to 2020, there had been applications made and none of these had been approved.
Mhm.
And I understand that the parcels are different size and so on and so forth, but this was not even addressed in the document that was provided me by the county.
And I don't, it's not relevant because they're subject to totally different standards. Two of them are forest template dwellings, is my understanding, and one's a conjunction with a farm use on high value farmland. So those are totally different criteria
I,
than what you're
right,
subject to.
I understand that. What I'm getting at is that it just seems strange that the statement that you just made was not included in the staff
Mhm.
report.
Yeah, I understand, but I don't think it affects the decision in any way. It would have been good to say that, acknowledge that um, they're different standards, but I don't think it affects the decision.
Yeah, understand. Next slide, please. This is just a map
Those are
showing
where those are.
where those 3
Yeah,
are.
yeah.
The next slide shows specifically where those residences have been approved.
Mhm. And again,
Next,
I don't think it's relevant, so if we can move on from that issue.
okay, but okay, all right, that's the slide that we're looking at now. Then
Yep.
the next slide shows
Mhm.
an aerial photograph of those. And the next slide shows the plot plan that
Mhm.
approved the one directly across the road from us. Next slide, please. This addresses in more detail what we talked about earlier regarding the on-site inspection not being made by the county. And I just found it interesting that if you go to the next slide, this is now what that replacement dwelling application looks like. Or in other words, this quick summary is that statement that an on-site inspection by the staff will be made, that's been removed. It's no longer in the replacement dwelling agreement.
What the replacement, sorry, let me see if I can phrase my question. When you say the replacement dwelling agreement, that form that the county has, is that what you mean? The county's current form?
That's correct.
Okay. So there's you haven't signed a new replacement dwelling agreement or anything like that. It's
No,
just they changed their
that's
form.
correct.
Okay.
That's correct.
I just wanted to,
In doing the investigation, I just found out that the
Sure.
item of concern to us has actually been now removed from the form that the county is using today.
okay.
Okay, next slide, please. This may seem to be a smaller item, but after I learned of the application being denied or that it would be denied, I met with Aldo in the staff office on the 22nd of October, and I specifically asked whether the comments that could potentially be submitted by neighbors would be provided to me. And he stated, yes, you'll receive those when you get the decision from the county. I did not receive those with the decision from the county. I went into the county office again on the 22nd of December and were provided copies of those letters by Taylor Campy. And then, just not pertaining to what we've already discussed, but I've learned that within the last 3 days, there's been an additional 3 letters submitted by neighbors.
Mhm.
Okay, next slide, please. Okay, and this would most likely be something that you would make a comment on, sir, in that the residences in the adjoining area were approved,
Mhm.
but for a different reason, our application has not been approved. Next
Mhm.
slide, please. What I'd like to discuss here is how the information is consistent as far as reasons provided for denial of our application. The first statement, which is on page 8 of the denial document, states the application is being denied because 1967 apartment dwelling was replaced with a manufactured home in 1998. The next one states it's being denied because one of the 2 dwellings was supposed to have been demolished or repurposed as an accessory structure in 1998. Well, that, as we've discussed previously, that in fact has been done. It's been repurposed.
Mhm.
So it's one of the 2 statements provided as a reason for denial is not accurate. Next slide,
But if
please.
I understand that they changed their wording, but if it was repurposed, that's the word, it's no longer a dwelling. So how does it meet the criteria?
We'll cover that in a
Okay.
bit here.
I understand they changed their wording. They could have been more consistent, but that seems to be the issue. Go ahead.
Okay. Well, my interest is that what is stated is accurate. And in this first boxed area, it says it was established,
Mm-hmm.
it was lawfully established in
Mhm.
1967. The next one says that it is no longer a lawfully established dwelling. Well, it was lawfully established. The real question is whether it's lawful today or not.
Mm-hmm.
Okay, just like I said, may seem to be a minor detail, but when statements are important, it's important that they're worded correctly.
Okay. Well, I
Next
think
slide,
whether
please.
it was lawfully established in 67 is the first criteria, and that's met. That staff agree, and I do too. The issue is whether the following criteria are met. So the wording could have been better, but I just want to focus on what the criteria are and whether they're met. So I appreciate you're wanting accuracy and clarity, but go ahead. Go ahead. I understand your argument.
Okay, thank you. Next slide, please. This is out of that same replacement dwelling agreement that was signed in 1998.
Mm-hmm.
And I find it interesting that number 3 states, if the existing residence is retained on the property for other than residential purposes, any subsequent purchasers shall be advised in writing that the structure may not be used as a residence.
Mm-hmm.
again, I just find it interesting that the criteria is that it's supposed to be removed, restructured, whatever, but yet it says that if it's left on the property, then any subsequent property owner should be notified. So
Sure. Because somebody
if
could just
it's supposed to be,
reattach the plumbing and rewire the stove, and then they've got an apartment, but they need to know that they can't do that. That's what that statement is required for.
yes, all right. Let's move on to the next slide, please. I mentioned that we would be coming back to this, and
And is this okay, I just see the replacement dwelling agreement. I was looking for the title. Go ahead.
right, this is again out of the replacement dwelling agreement. This is item number 1 that says removed, demolished, or physically changed. And earlier you asked me what the relevance of those words
Mhm.
actually are. And the reason that I found that it would have been helpful had planning staff come out to investigate would have been that the action that we took was totally on our own. And that was pointed out earlier. Uh, let's look at the next one. The next slide, please. On the insert, this is from a sewage disposal system inspection report from 1998. It says, remove the kitchen from the shop per planning requirement. Number 3 says, remove or convert into an accessory structure. Number 4 says, demolish or converted. A lack of clarity is what I'm concerned about. There's no specificity at all in terms of if you do these 3 things, then you've complied with our request. But the multiple terms, remove kitchen, demolish, convert to an accessory structure. Well, we've complied with, one could say, every one of those, and it is no longer being used as a residence. And yet in the staff report, it clearly states on numerous occasions that we've not done that.
I understand.
Next slide,
But if you
please.
have, it appears you have complied. You did cease using it, excuse me, using it as a residence. But when you did that, it's no longer a dwelling. So how do you meet the other criteria? That's, I understand you prefer some more consistent statements by the staff, but if you did that, then it's no longer a residence, so it's no a dwelling, so it no longer meets the criteria, is my understanding. Or that seems to be the basis for the county's decision, even though they worded it differently.
Well, we'll come to that again
Okay.
in terms of, well, I would just state, and there's information in here that I highlighted, where it repeatedly states that the dwelling was not converted. And
based on your evidence, that's inaccurate. It was converted.
Thank you. Okay, let's move on to the next slide then. Slide 40, vague information. This phrase regarding currently lawfully established, we've already discussed that. It's not clear. Item B, how to disable the residence. It's inconsistent, different wording. Photos provided clearly show that it does meet the criteria. Next slide, please.
the criteria for conversion to a non-residential use. Is that what you mean?
Right, that's
Okay,
correct.
okay.
Okay, this is just a summary now.
Mhm.
And this is a direct comment out of the staff report. Staff received numerous written comments from neighbors within 750 feet in support of the approval of the application or stating they have no issue with the application.
Mhm.
Next. And again, this is out of the staff report, a review of current
Mhm.
county assessor appraisal data as well as photography confirms the dwellings currently exist on the property.
Mhm.
Okay, next one.
So I've read all this. You don't need to read it again.
Yeah, I don't plan on
Okay.
reading these longer ones. Okay. And next slide, please.
Mhm.
Clearly, the information relative to taxation as presented by the planning commission or planning and zoning department was incorrect. Next slide, please. Okay. And I presume that you've read this as well. We have been paying taxes for 26 years on an apartment in our shop building that is not legal. And I have a problem with that. The county assessor's office clearly stated that we have been paying those taxes, and in some way there needs to be retribution for that.
And that seems like you could have appealed to the county assessor saying that that apartment's gone, is no longer used as an apartment, and had your taxes modified based on that. But it doesn't seem to affect the approval criteria that I have to apply. I understand your argument is not fair, but fairness isn't something I get to consider in this proceeding. The only issue before me is whether these approval criteria in the county development code are met. So I understand your fairness argument, but it's not something I can consider.
Okay, so the requirement is that it be converted to a non-residential use. That has been met.
Mhm. But that's not the criteria I have to apply. That was what was required for the replacement dwelling in 98 or whenever it was. So that, and based on, it appears to be that happened. But when that happened, that residence, that dwelling ceased to exist. So you don't have two dwellings on your property anymore. You have one, the stick-built house. So you don't meet the criteria. Specifically, 406, this is page 9 of the staff decision, 40609B. Multiple dwelling land divisions, a lot of record, may be divided subject to 40605A2 and the following provisions. Number 3 on page 9, each dwelling complies with the criteria for a replacement dwelling. Number 1A, the dwelling to be altered or restored or replaced has or formerly had the following features. Formerly had means the dwelling possessed all the listed features within 3 years of the date the application was submitted. And those features include specifically bathing facilities. Well, intact exterior walls and roof structure, that's met. Indoor plumbing consisting of a kitchen, sink, toilet, and bathing facilities. You said that you took out the shower by putting the hot water heater into there. So it no longer has bathing facilities. So that criteria is no longer met.
Okay, so
Right.
all we'd have to do would be to remove the hot water heater from the shower. Is that
But
correct?
you can't legally do that because you had to remove it to make it in order to get approval of your mobile home replacement dwelling in 98. So at that point, it ceased being a dwelling. And that criteria ceased being met and hasn't been met for the last 26 years. So you can't go back and in effect, you're trying to double dip here. You got approval of a replacement dwelling, which you couldn't have gotten without removing this apartment. And now you're trying to bring the apartment back and get another dwelling. So you have 3 instead of 2. And that's the issue before me, is whether that apartment is a dwelling as defined and meets that standard. Because it didn't have the bathing facilities for the past 5 years prior to the application being submitted. And that's what the standard is. I'm not ruling on this, but this is just my reading, and I want to get, so I'm giving you a chance to respond, to argue that I'm wrong.
I believe in section 1307 that there's reference made, and I don't have it in front of me, but it has to do with the county assessor's office needing to be notified. And you're no doubt a lot more familiar with that than what I am. And
Actually, this is the first time I've seen a replacement dwelling. This particular issue, let's put it that way. I'm pulling up the code real quick, so I can see if I can find what you're talking about. 1307, is that what you said?
I believe that's correct, yes.
Procedures. And it's something about the assessor.
Yeah, it's
Google that, or just search for that term. Oops, what did I do?
it's it was item, I don't have the page number
Okay.
in memory, but it was sub-item I.
Yeah. And Mr. Kruger, you have the right to submit a final written argument after the hearing. So I can hold the record open so you could find that provision and make an argument about it, or any of these other, excuse me, any of these other issues that we've talked about. So that may be the best way to proceed on that, because I'm not finding any reference to the assessor in 1307. It may be a different code criteria. But I'd like to know what it says where you're making that argument and how it's relevant.
Okay, that's fine. Okay, next slide, please. Okay, these are the marked up,
Mhm. And based on those, it looks like it was assessed as a residence, and that's why I asked the staff if they'd respond to that, and I'll give them a chance to respond again. But based on this, it appears to me it was assessed as a dwelling for the past 26 years or whatever it was. That's unfortunate, but it doesn't affect the criteria that I have to apply. You kind of talk to the assessor's office and see if you can get at least the more recent assessments changed. I'm sure there's a statute of limitations as far as how far back you can go for these changes. But the issue before me is whether the dwelling is lawfully exists right now. And it doesn't appear that it does.
okay, so what concerns me is the lack of communication between the planning department.
Understandable. But this is something that the county's not required, the county planning department, let's put it that way, is not required to notify the assessor. I think that burden's on you as the property owner to notify them of changes. I didn't see anything in the code that requires county to notify the assessor when that happens.
Well, that's what I'm referring to as far as this 1307, I believe.
Mhm.
I'll look that up, and
Okay.
it could be not pertinent to our situation.
Mm-hmm. And if the county was required to and didn't, potentially, I can't give you any legal advice, but arguably you may have a cause of action against the county. I have no idea. But again, even if you did, it doesn't affect this approval criteria that I have to apply.
That's all that I have right now, unless there's information provided that I need to respond to today.
Thank you, Mr. Kruger. I will take staff from any member of the public that wants to testify. I'll give staff the opportunity to respond to your testimony. Then I'll give you the final word, so you'll get a chance to respond to the staff and the public, if any. And I will also give you the chance to submit a final argument without any new evidence. If you wanted to submit new evidence, you can ask me to hold the record open for that. But the final argument, you get that whether you request it or not, unless you waive it. So that's what we're going to do next. I see one hand raised from Tim. Can we unmute them? Tim, you'll need to unmute yourself. It looks like, there we go.
Okay. Hello, Tim Kruger. Can you hear me okay?
Yep.
Tim Kruger, Krueger.
Thank you.
Address 18310 South Old Clark Road.
Mhm.
So I live adjacent to this to the properties that have been in discussion.
Mhm.
The property line adjustment that Aldo mentioned early on in the call was completed last fall, and then Mr. Kruger had met on multiple, as he mentioned, he had met with planning staff on multiple occasions to, express his interest in this desired land use change. And it was recommended, that this multiple dwelling land division process would be the correct path to do that. And I believe that's why the property line adjustment and this multiple dwelling land division application process were pursued, because through discussions with planning staff, it was, advised and recommended that was the right path.
Mhm.
And I just want to offer that as the reason for why all this has been pursued.
Thank you, sir.
Yes.
If you're done, can you click on the raise your hand button so your hand goes away, and go ahead and mute yourself again. Is there anybody else who'd like to say anything about this application? If so, please click on the raise your hand button to indicate that. And I'm just pausing to give everybody a chance to find said raise your hand button. I'm not seeing any further raised hands. Anything further from county staff, Mr. Rodriguez?
Yes. I'll say something and then kind of turn over to Lindsay here as well. In the applicant's testimony, he mentioned the house was decommissioned and used for non-residential purposes. I think just wanted to note that staff aligns with that determination as well.
So you agree that it was decommissioned?
Correct. And
Okay.
And it's currently not lawful as well. And anything else, Lindsay, you want to add?
Yeah,
I'm sorry, when you say not lawful, you mean as a dwelling?
Correct, sorry.
Yeah,
exactly.
I assume so. I just wanted to make that clear.
Yeah, thank you.
Right. For the record, this is Lindsay Nesbitt, Planning Manager with Clackamas County. And I think Mr. Turner, with your summary at the end of Mr. Kruger's presentation, we don't have any additional comments on the dwelling. I do acknowledge that setting up the staff report in this situation was a little bit difficult because the dwelling was originally lawfully established, and then we were, processing the land use application for a multi-dwelling land division. So then the applicant, was presenting that it was a dwelling. So I do appreciate the feedback of paying attention to those details in the staff report and trying to lay that out just a little bit more clear. But there were a lot of unusual factors in this decision. So
Yeah.
and then, sorry, I do believe that Aldo in the decision was going off the value of the apartment dwelling, that the assessed value, and comparing it to the value of the dwelling that was replaced, or the other dwelling on the lot. Anyways, and so I just think he was saying it wasn't assessed because the valuation was so low, but I think the documents today suggest otherwise.
So you agree it was assessed as a dwelling?
Or
appears to be, based on the
it
document.
appears to be, yes.
Okay.
And then again, similar to those, it's, as the property owner, it seems that the onus would be on the property owner if they're noticed that their tax bill is assessing something that isn't accurate, that for the property owner to go to the assessment taxation office and request to have that corrected, so.
I'm just writing my note. Thank you. Mr. Kruger, anything further you want to add before I close the hearing? I'll hold the record open so you can submit a final argument. Mr. Kruger, I think you're muted. There we go. Now we hear you.
I would like to just restate my sincere frustration with the Planning Commission and the lack of continuity in terms of what I was specifically told, the guidance that I was provided, understanding that that's not legally binding. But when I'm told something, the way I operate is that I live by what I say. And I've clearly found that not to be true in this case. That's really all I have to say today. And yes, I would certainly like to have the record held open.
Is a week sufficient?
Will there be anything else submitted by anyone else? Or
No.
it's my understanding that I will have, I mean, if no one else is stating today that they plan to submit something
No,
else.
I'm going to close the record for everybody except you at the when you're done. So you're the only one who has the chance to submit anything else, and that is only argument. You can't submit any new evidence. If you want to submit new evidence, I can hold the record open for that purpose, but then everybody gets the chance to respond to the new evidence as well. If it's just argument, it's just you.
Let's go with the latter.
Okay, and is a week sufficient for you to submit that
Yes.
argument? Okay. In that case, I will close the hearing. I will hold the record open for 1 week. Let me grab my calendar. So the 30th of January, I'll hold the record open until the 30th of January at 4:30. Is that correct? I'm asking staff. Yes, 4 o'clock. Okay. Anything your final argument has to be physically received by the county by 4 p.m. on January 30th. And then they'll forward it on to me. I will try and get my decision out within 2 weeks after that, which would be February 13th. I will send my decision to the county. The county will send it on to parties of record, which is anybody who's testified orally or in writing. But that concludes our hearing. Thank you, Mr. Kruger. Thank you, staff. Have a good afternoon.